Okay, the court will address the last case on the docket this morning at this time, which is RIZZO as personal representative against John Doe in Westgate. All right, sir.
Good morning, Your Honor. Alex Brockmeyer on behalf of the RIZZO estate. There are two issues presented by this appeal. The first is that concerning the applicable duty of care that Westgate owed to Mr. RIZZO, and then second, whether that duty of care was breached. As to the duty issue, Westgate on page 5 of their answer brief agrees that the applicable duty supplied by Florida common law and that by the restatement second of torts are one and the same, and that duty is to provide reasonable first aid to a individual that it knows to be injured under the circumstances. Now, the case law in defining what constitutes first aid identifies...
Your position is they have a duty to use reasonable care, and repositioning a body fell within that duty.
Yes, Your Honor, absolutely.
Now, that's what this issue is in this case.
Yes, Your Honor. And because that...
This employee was a security guard?
Yes, Your Honor.
And refresh my memory about the extent of his training.
What we know from the
As it
record...
relates to first aid.
Well, as it relates to first aid, actually, it's interesting the interplay between those, because first aid is going to be an act that doesn't really require any medical training to be able to perform.
What medical training did the security guard have?
There does not appear that Mr. Fairclough had much, if any, training. There is another individual, an employee of Westgate, Mr. Edelmere, who testified that he went through, and employees of Westgate went through CPR training as a general matter of course. However,
your client's, was it the decedent's wife that alerted the security guard?
Correct, Your Honor. Ms. Rizzo called
The security guard. He came into the room and saw him laying on the chair, I guess, or a piece of furniture, right?
Yeah, yes, he was lying in an awkward position. He would be at an incline almost. You have...
His chin was on the chair, his torso was elevated off the ground, and his rest of his body's on the ground, so he's kind of at an angle.
Absolutely, Your Honor.
Ms. Rizzo, she's certified in CPR, she's talking to 911, and they suggest that Mr. Rizzo needs to be supine, put on his back.
Correct, and Ms. Rizzo...
Because the point being is put him on the back in the event CPR needed to be administered.
100% absolutely correct, Your Honor.
And so Mr. Fairclough comes there and he looks at Mr. Rizzo, and Mr. Rizzo has a pulse and he's breathing.
Well, I would just add into that recitation, Your Honor, that Mr. Fairclough refused to turn Mr. Rizzo over.
Yeah, we wouldn't be having this discussion if he turned him over.
Well, I guess what I wanted temporally, the refusal to turn Mr. Rizzo over occurred prior in time to Mr. Fairclough checking the pulse and confirming or checking to see if Mr. Rizzo was breathing.
Okay, so, but in any event, he's breathing. Fairclough says he's breathing.
Yes.
And Mrs. Rizzo doesn't dispute that he's breathing.
No, I just, in terms of, if I'm maybe reading too much into the court's question, but if there is, Your Honor, suggesting that a basis for the refusal to turn Mr. Rizzo over was because he was breathing.
No, that's not,
okay.
You're reading too much into my question.
Okay.
I'm just from a factual standpoint, Ms. Rizzo wants to have her husband turned over. She's talking to the 911 operator. She wants them to be turned over in the event she has to administer CPR because she is CPR trained.
Yes.
And you wouldn't administer CPR to somebody who's breathing and has a pulse.
Correct, Your Honor.
Okay, and so when Mr. Fairclough says, all right, he said, I can't, so, and that's not being helpful in Ms. Rizzo's mind. But when apparently the paramedics are on their way, everybody agrees the paramedics are on the way, so Faircloth goes out to basically find the paramedics and direct them expeditiously to where Mr. Rizzo is.
Yes, correct, Your Honor.
Probably went out there, you didn't go out there to direct.
Correct, and then Mr. Fairclough comes back into the room for a second time, tells Mrs. Rizzo, look, tell EMS to come in through the back gate, and then he leaves again. And so,
But when he leaves, though, Mr. Rizzo's breathing.
the first time, yes. The second time that Mr. Fairclough comes into the room, the record isn't crystal clear as to what Mr. Rizzo's breathing condition was
Wasn't
like.
he supine at that point?
No, Your Honor, he's not.
not?
Mrs. Rizzo testifies that at the time EMS came into the door, through the door to her room, was the time that she had just turned her husband over onto his back. And by that time, by the time he was supine, he was blue. And so there are two instances in the record where Mr. Fairclough came into this room, had an opportunity to turn Mr. Rizzo over onto his back. The act of turning Mr. Rizzo over onto his back, just physically moving him onto his back so that he is supine, is an act of first aid within the...
Let's say he does that. Let's say, your view is he should have done that. Let's say Mr. Rizzo had some type of neck injury when he fell, and as a result of turning Mr. Rizzo over to be on a supine position, that exacerbated the neck injury, so now Mr. Rizzo is quadriplegic. When that, once you assume a duty to help, you have a duty to act reasonably, and if that is not a reasonable thing to turn somebody over, he's now exposed himself to liability because he helped.
Well,
I mean, I know it's a jury question, but he has now exposed himself. That he comes onto a scenario, he doesn't know the condition of the person other than how he's tilted. You turn him over, may or may not exacerbate a back or neck injury, and if he does that, then he's exposed himself. If he does nothing, then he's not exposed.
well, if he does nothing, I would submit to Your Honor that he still has, there's potential liability.
Damned if he does and damned if he doesn't, right?
Well, but here's the thing, Your Honor. In this case, we don't have Mr. Fairclough's testimony to state that he thought Mr. Rizzo had a neck injury. We're speculating that that's why Mr. Fairclough did or did not act in the way that he did. And because we're sitting at summary judgment, I understand the court's concern, but there's nothing in the record to suggest that Mr. Fairclough did not act in turning Mr. Rizzo over because he thought that there was a neck injury. And there's nothing in the record to suggest that Mr. Rizzo did in fact have a neck injury. Now, I know that Westgate brings attention to the fact that there was the cervical collar placed on Mr. Rizzo by EMS when they arrived. However, Mr. Waters, and this is on page 913, lines 16 through 25 of the record, states that the reason the C-collar was placed on Mr. Rizzo was because they needed to intubate him, and the intubation in the C-collar keeps that intubation tube in line so that nothing gets messed up and so that the breathing can occur correctly. But going back, Judge Lambert...
Let me ask you a question about the breathing. So when Mr. Fairclough came in and initially assessed Mr. Rizzo, there was information on the record that he appeared to be breathing, correct?
Before or after he refused to
No,
turn him
I'm talking
over?
about the initial assessment of Mr. Rizzo. And then at some point after that, Mrs. Rizzo testifies that he started to turn blue, correct?
Correct.
All right, in between that, was there ever a change in information to the security guard saying, now we do not believe that he is breathing?
Well, first, Your Honor, when Mr. Fairclough enters the room and he initially refuses to turn Mr. Rizzo over, he does not know that Mr. Rizzo is or is not breathing. This is on...
Record evidence at some point that comes from the wife that he was breathing, correct?
Correct, Your Honor,
Yeah,
but...
so my question is, after that time and the time the paramedics came in and the security guard was ever exposed again to Mr. Rizzo to assess the situation, was the security guard told, now he's not breathing?
From the record, it does not indicate that that was made available to Mr. Fairclough. What we do know is that Mr. Fairclough comes into the room the very first time, and he says, before assessing Mr. Rizzo's condition, Mrs. Rizzo says, "I need you to help turn my husband over." And Mr. Fairclough says, "I can't." Now, this is on page 822 of the record. This is when Ms. Rizzo lays out that initial encounter. Mr. Fairclough had not checked the pulse, had not checked to see if Mr. Rizzo was breathing. Now, certainly, a jury could look at what Mr. Fairclough did and said, well, he was breathing at the time. I understand why you didn't turn him over. You acted reasonably. But I think Judge Lambert hit the issue right on the head, which is, it's a question for the jury, because what we're talking about here is the reasonableness of the conduct in the aid administered by Mr. Fairclough and Westgate here. There's nothing to indicate that Mr. Fairclough could not have turned Mr. Rizzo over onto his back or side so that he could be administered first aid if it becomes necessary. And what we're really looking at is what Westgate on page 13 of their answer brief contends to be the most instructive illustration in the restatement second of torts, which is the illustration number 5 in the restatement. And what that illustration deals with is you have an individual at a theater or a play, suffers a cardiac arrest, and the individual asks, I need help being moved. And the movie theater or the theater there does not move that individual to a place where he could receive medical treatment if it became necessary. And what the illustration says is that the theater, by failing to move that individual to a place where he could receive medical care, is liable for the aggravation of that their guests' injuries. And that's exactly what we're contending here. Mr. Fairclough and Westgate failed to move Mr. Rizzo over onto his back or side. Reasonable or unreasonable, that is a jury question. That's what Lemonis versus Lee County School District tells us. The reasonableness of the acts done by a defendant is a question of breach, and it is a question for the jury to assess. And because Mr. Fairclough did not turn Mr. Rizzo over onto his back or side, it is not out of the realm of possibility that a jury could look at Mr. Fairclough's conduct and say, you know what, you walked into a room, you saw a 270-pound man lying in a contorted position, you should have got him lying flat and on the ground.
Well, the restatement also, 314A, the business owner is not required to give any aid to one who's in the hands of an apparently competent person. I understand that's generally, if there's a doctor present, who have taken charge of the injured person, or friends who are present and apparently in a position to give them all the assistance necessary. I mean, what you're telling me eventually is Mrs. Rizzo got the man supine, Mrs. Rizzo is CPR trained. So that's what you wanted Mr. Fairclough to do to give him in a position to be administered CPR. When he left the room the first time, CPR was unnecessary. There seems to be a focus that his initial reaction is, I'm not going to move him before he's assessed the scenario, even though the assessment a few seconds later indicated there was no need to perform CPR at the time, is somehow a breach of a duty, or the duty exists to do that. I'm having a hard time with this leap that you want us to take.
Well, Your Honor, what we're looking at here is, I agree, he comes into the room the first time, refuses. Then you say, okay, well, he confirms proof of breathing.
You seem to make it significant that if he had come to the man first and said he's breathing and he's got a pulse, I'm not going to touch him, that's of enormous significance in the analysis of this case.
In my analysis, Your Honor, I guess let me make this clear. It doesn't, the temporal sequencing doesn't make much difference. The fact is that Mr. Rizzo needed to be turned over. The act of turning him over was within the scope of that duty. That act was not performed. And what we're looking at then is, was that reasonable?
How did the guard know that he should turn him over?
Sorry, Your Honor, can you repeat that?
How did the guard know that he should turn him over?
Well, what we're looking at here is, you see, common sense would dictate a normal layperson coming into the room would see a man lying in this position. You would say, I need to get him lying flat so that...
I mean, common sense would tell you if somebody was laying with their face in a puddle of water, that you would turn them over so they could breathe. I'm not sure that common sense, indeed, isn't it possible that moving somebody that has fallen might further injure them?
Well, it's a possibility, Your Honor, but possibilities don't crystallize facts to justify the granting of a summary judgment, and that's all we're really...
From the standpoint of duty, though, the question here is, what, you're saying that this security guard had a duty with minimal or no first aid training, just as a lay person, that he had a duty when seeing somebody who had fallen to move them. And what is the basis of that duty?
The basis of that duty comes from the case law that in identifying what type of acts constitute first aid, Cells out of the 1st DCA, LA Fitness from the 4th.
Well, LA Fitness says the business owner satisfies its legal duty to come to the aid of a patron experiencing medical emergency by summoning medical care or assistance within a reasonable time, which occurred here.
Well, but it goes on, Your Honor, and it's important to note that in making that statement, first of all, LA Fitness cites to the Pacello case out of the Connecticut Superior Court for the position that the duty is to provide reasonable first aid under the circumstances. And LA Fitness continues on to define first aid as those acts that require minimal or no medical training, and then in identifying those types of acts that are the quintessential examples of first aid, it says positioning. Just like Cells does, it says positioning an individual is an act of first aid. And then we look at Abramson from the 3rd Circuit. Abramson, in identifying what type of acts constitute first aid, say positioning or repositioning an injured individual is an act of first aid. And then finally, Pacello from the Connecticut Superior Court says an act of first aid, example is positioning. And then it interprets...
Under the circumstances.
And then we get to what...
And the security guard is one of only 2 people that were there that was able to assess the circumstances, correct? I mean, they got the 911 operator on the phone, but he or she is not able to actually see what's going on.
Correct, Your Honor, and the only testimony that we really have here is Ms. Rizzo's. We do not know why Mr. Fairclough did or did not act the way he did. And because of that, as the moving party, Westgate can't really say why what Mr. Fairclough thought and did was reasonable under the circumstances. They, as the moving party, bear the burden of crystallizing the facts to show that they are entitled to judgment of law, and in order to do that, to show that there was a breach, or there was no breach as a matter of law, they have to be able to set forth the facts as to why they did or did not do what they did. And we don't have those facts here. We do not have Mr. Fairclough's testimony stating that I did not move Mr. Rizzo because of a neck injury or because he was breathing. We do not know why Mr. Fairclough didn't do what he did, but because we do not know why he did not perform this act, which is an act of first aid, that puts into question the reasonableness of his conduct, and that is a fact question for the jury to decide. And because we have that fact question, we would request that this court reverse the final judgment and remand for further proceedings. Thank you.
All right, so you got a little less than 2 minutes for rebuttal.
May it please the court, Isaac Ruiz Cruz on behalf of Westgate. I want to discuss precisely what happened that evening from what we know, and that is the plaintiff's own testimony. So, this is in her deposition, which was the summary judgment evidence before the trial court. Pages 87 and 88. They'd returned from going to get some Tums at about 10:30 at night, she and her husband. Come back into the room, and he opens the door and holds the door open for her. She walks in first, goes into the dining room. She said as she's walking to the dining table on page 87, she hears a whoosh sound. When she turns around, he's collapsed. As the plaintiff's counsel pointed out, he lands on a chair in a contorted position. So his chin is up on the chair. I can't recreate this. I've tried. His chin is up on the chair. His face is forward. He's a very large man, 300 pounds, the record shows, and his stomach is holding his body up so that his chest is in the air, but his stomach and his legs are on the ground. And she says, she calls security. And then, this is on page 91, she hangs up with security and calls 911. She says on page 92 that he appeared and sounded to be breathing. This is before the security guard even comes in. I could hear him breathing, she says at lines 17 and 18. The security guard comes to the room. She says on page 96, there was a knock at the door. It was the security guard. I opened the door. I let him back in. I told the security guard I needed him to help me turn my husband, either on his side or on his back, in case I needed to do CPR. He told me I can't. Then the question is, did the security guard provide any further explanation as to why he couldn't help? He provided no explanation, but after he told me that, he proceeded to put his hands to my husband's neck, told me that he had a pulse, and that he was breathing. So the first thing that this untrained security guard does when he comes into this room and assesses the situation, he sees a contorted body of a man, a very large man, who apparently has fallen and is unresponsive. Common sense would dictate that you don't move someone who's fallen because there might be a neck injury, there might be a spine injury. And he checks if he's breathing, and he checks if he has a pulse, and he confirms that the paramedics are on the way, that is, that 911 has been called. He does not do what the wife asks him to do, and that is reposition the body. The first thing she does, and you can imagine the scene, here's a wife on the phone with 911, probably panicking, saying, help me out, can you turn him? He says, I can't, and proceeds to immediately check him. He then tells the wife, and this is on page 97, that he's going to wait for the paramedics. This is a very large resort with multiple gates. In one of the other cases, and we'll get to in a minute, one of the plaintiff's arguments in another case was that there was a duty for Ritz-Carlton to actually help get the paramedics to the room as quickly as possible. The court found that there wasn't any failure with respect to that, but in this case, we actually have a security guard trying to get the paramedics to this precise room. It's not that easy to find it. And he actually says to her at page 97, line 24, he was going to meet the paramedics or open the gate for the paramedics. So what we know is that when he's there in the room, that Mr. Rizzo is still breathing, that he has a pulse, and that 911 is on the way. And the security guard leaves to get the paramedics to the room. He comes back a second time. Mr. Rizzo's still in that same position, and he's just checking, and he goes back out to help get the paramedics in. Sometime between then and when the paramedics arrive, Miss Rizzo manages to move her husband's body off the chair.
So after the security guard came back a second time, just to double check, it's still the status quo?
Yes. And so,
In other words, he's breathing?
We don't know. The record doesn't say whether he's breathing or not. But at page 102, here's what we know. There's no indication that his color has changed yet. She moves his body, and this is a very large man, off of the chair, and this is at page 102, line 19. I actually held his head and brought his head down to the ground. Okay? So now he's still face down. He's not face up for some period of time. During that period of time, she's struggling to turn him over. It's at that time, once she's moved him off the chair, that he's now face down against the ground, that he starts to turn blue. She says she just manages to flip him over as the paramedics come into the room, so she has yet to initiate any CPR. But at page 103, he's still breathing when he's in the position the security guard sees him in. It's not until after she moves him and he's now face down against the ground for some unknown period of time. She doesn't know how long he's in that position. A few minutes, perhaps. He then turns blue. So the question becomes then, as a matter of legal duty, The plaintiff's position is that this untrained security guard has to have one of two things. One is, as a matter of law, if he finds a body in this position, he immediately has to render aid, and that includes repositioning the body. Now, why would a security guard that comes into a room and sees a body of a large man in a contorted position, confirms that he's breathing, confirms that he has a pulse, confirms that 911 is on the way, why does he have any reason to move his body? Where does that come from? The only source of that in this case is that the panicking wife that's on the phone says, "Help me move his body." But how does he know that she's CPR trained or that she's a medical professional? There's nothing in the record to say that she said that to him. She said she wanted his body turned so she could, if necessary, administer CPR. I guess you could assume that that meant that. But essentially the source of
That, or did she just ask him to help her move?
She said, according to her testimony, she said that she told the security, when she called security, that she needed help turning the body to side or back so that if necessary, she could provide first aid, or CPR. But the point is, in order for
What is the extent to which an individual must put themselves at risk by rendering first aid? I mean, here you have, how old was the security guard?
How old was the security guard? I don't know. I don't think that the record indicates, Your Honor.
Doesn't have any.
I know his height. He was approximately 5'5", and he was Jamaican.
A rather heavy person, the security guard might hurt himself. I mean, what is the extent to which a person who is rendering aid must personally risk themselves?
And we would suggest that not to the extent of having to turn.
Is there any law on that? In other words, does a bystander have it? We saw in the news last night that lion pulled that sea lion pulled the little girl into the water. Does a bystander have a duty to jump into the water? I would hope everybody would do that, but do they have a duty to jump into the water, try to rescue the girl?
They don't. Generally speaking, they don't. If they do begin to undertake it, then under various Good Samaritan doctrines, et cetera, they might be protected depending on the scope of the action that they take, but there's still a standard under which they could be liable. But as far as we're talking about a business invitee as opposed to just an observer who happens to see a little girl get pulled down by a sea lion. This is a business invitee. So we are dealing with a slightly different standard than just the observer, but the standard of the business invitee, the commercial relationship, is different than the relationship that the appellant is urging this court to follow, that is of the school district with respect to its students in the Limones case that the Florida Supreme Court decided. With respect to the business invitee, you more than likely, what the Florida Supreme Court said is that you have adults on both sides and you have parties that are sort of willingly entering into the commercial relationship. So it isn't the same type of duty. The LA Fitness...
Duty's higher for the invitor, the business.
Correct.
Than a bystander.
Correct. It is higher than a bystander, but it is lower than the school district that sits in loco parentis with respect to its students. The LA Fitness case is extremely instructive in respect to what did, and in that case it was an athletic trainer, which is actually a certified healthcare professional under Florida statutes, but it was athletic trainers at LA Fitness that had someone who was in distress on one of the machines, falls, hits his head or hits something, and the first responder makes sure 911 is called, determines that he's got a pulse, does not check whether or not he's breathing, but the trainer decides to not give CPR. He just starts to turn blue when the paramedics arrive. And the court in that case, and this is the 4th District Court of Appeals, found that there was no duty of care with respect to the different allegations of negligence by LA Fitness, the healthcare facility, the gym where this guy was working out. Now, the scope of that was whether or not an AED should be provided, and that was where the arguments, and with respect to whether CPR should have been given and whether or not there was appropriate training given to those professionals. But what the appellant here is arguing is that because of the use of the word first aid in the restatement second of torts, 314A, that you have to look to see what first aid means. And if you look at the various sources of first aid, there are included in those sources from times the phrase repositioning. And so they go to the Pacello case, Pacello versus Wyndham International, and that's where there's a reference to, and it spells out what the American Heart Association and what the American Red Cross say might be encompassed within first aid with respect to their guidelines. And so if you follow the plaintiff, the appellant's argument here, it's that those things that are covered within the scope of these guidelines automatically have to be done by a business when there's a business invitee that they find ill or injured. And those things include positioning the victim, which is one of the things that they've urged that this court follow. But it's also got...
Priscilla, you have to rinse an avulsed tooth with water and place it in milk for transport to the dentist as part of your duty as an innkeeper or a business owner.
Precisely, and that's where we think that this is taking this to the absurd.
I've never known that.
Quite frankly, we think that this should be governed by the facts and circumstances that are before you. And the facts and circumstances determine the scope of the duty. And when you look at other cases in Florida involving business invitees and what was done in particular by the business or its agents, its employees, with respect to that invitee, was this case, does it fit within the scope of the duty that's been previously looked at as being within the scope of the duty or not within the scope of the duty? We think, for example, that if you look at the first case that we mentioned, which is the LA Fitness case, that if here the security guard actually did more than the LA Fitness trainer did, clearly there is not an expanded scope of duty, that there isn't something more that the security guard should have done. Another case that we cited is Cocorello versus Round Table of Coral Gables, a third DCA case. It was a summary judgment case. And there was a restaurant patron who started choking in the restaurant. And while choking in the restaurant, the employees of the restaurant called the rescue team, which arrived within 5 minutes. Motion for summary judgment on whether or not there was a duty to do more, citation to the restatement second of torts, 314A, and the court affirmed the grant of a summary judgment that that business owner and its employees didn't have a duty to do anything more with respect to that particular individual that was choking at the restaurant. Now, the second issue really that's been raised is this issue with respect to whether this is a jury question. And what the plaintiff tries to urge this court is that once the circuit court made a determination that we have an innkeeper or a business owner, that then we know what the duty of care is. The duty of care is that if you have an ill or injured patron, that you're supposed to get them medical attention or provide aid until medical attention shows up. And they think that that ends the judicial inquiry with respect to what the court should or shouldn't look at for the scope of a duty. Now, we know from the LA Fitness case, we know from Limones itself, we know from case after case that the question of whether or not whether or not there is a duty of care at common law for a particular action, which is what we're dealing with here, a common law duty of care, that is a judicial question. And sometimes the lines between the duty of care and breach of that duty of care are blurred. But here, we're not in that blurred territory. We are firmly within the scope of, we have a business invitee, we know that the business, through its security guard, made sure that the business invitee was breathing, that he had a pulse, that help was on its way. He was in a contorted position, so he did not alter his body. With respect to that last fact, I did want to add one thing, and that is when EMT showed up, this is Mr. Waters, an argument was made by appellant in the brief and now at oral argument that Mr. Waters, the EMT, only did the cervical collar because they wanted to preserve the alignment of the neck with respect to intubation. But at page 19 of his deposition, the question was posed, is there any indication in your report that there was any concern of some sort of spinal injury at any point? And his answer begins with, well, the patient did fall face first. When we have a cardiac respiratory arrest, when we work up a code, we end up doing C-spine precaution. So he does go on to explain that they put the cervical collar on and that it helps maintain the airway. But this is someone who fell face first. And as we've discussed with respect to this concept of common sense. I think common sense would be that you don't move someone that has fallen, especially in a contorted position, because there could be the risk of a neck injury. In fact, that's in the AHA, American Red Cross guidelines as well, that you don't actually move a neck or spine. You have to make sure that it's aligned. So now you have competing guidelines, which one should be followed. The last argument that I want to take up is with respect to this issue that, well, they should reposition because that's first aid, and all of these cases use the word repositioning. The concept of first aid universally is that there's no need to exercise any type of medical judgment. That's how Judge Torpy, the appellant, answered your question with respect to, well, there's no need for him to be trained. Well, maybe, but if you have someone in this type of position and they're breathing and they have a pulse, what tells you that you should reposition them? There was no need to administer CPR at the time that the security guard comes into the room and sees the body in the contorted position. So it's not until something changes that he therefore would have the knowledge necessary to say, okay, now we have to do something. Now we have to reposition the body.
So if the man was blue, for lack of a better term, when your security guard came in, do you think at that point the duty would have required him to assist Mrs. Rizzo to move the man so that something could be done to get color back in, breathe? Yes.
I think that's a different case.
So duty is an issue of law, but it's not an absolute. I mean,
There is a factual component. We know from McCain, going back as far as that, and really maybe even further back than that with Paul's graph, in another state entirely, we know that one of the issues with respect to that is the zone of risk. And we have to evaluate that factually, but that is a judicial determination, the zone of risk. And here, if anything, the actions...
Well, not breathing, too, the risk of harm to them from moving them is outweighed by the need to prevent imminent death from a loss of oxygen.
Precisely. But here, the zone of risk, if anything, was reduced by the actions taken by the security guard because he ensured that he was breathing, he ensured that he had a pulse, and then he went to get 911 and make sure the paramedics could find the room. Any further action could have exacerbated harm.
Did they defibrillate him in the field? I can't remember.
I don't know. I don't remember. They took him into once they secured him, they started trying to, I think, resuscitate him inside of the ambulance en route.
Were they successful in restoring his heartbeat?
No. No. If there are no other questions, then for the reasons urged here and in our briefs, we'd ask the clerk to affirm.
Got a little less than 2 minutes, Counselor, to finish up.
Thank you, Your Honor.
Thank you.
Counsel made the concession that we're dealing here with a common law duty, and Lamoni's tells us that when we have a common law duty, the court must simply determine whether the common law imposes a duty upon the defendant. Once the court has concluded that a duty exists, Florida law neither requires nor allows the court to further expand its consideration into how a reasonably prudent person would or should act under the circumstances. We have a common law duty that's to render reasonable first aid. The question then becomes what was or was not reasonable. And that is a question, as Lamoni's tells us, that is one of breach. And the cases of LA Fitness and Cocorello that Westgate cites as supporting the fact that there was no breach as a matter of law, briefly, are distinguishable. LA Fitness actually had an expert, and this is testimony set out on page 555 and 556 of the record, who stated that there the individual who was responding provided reasonable first aid under the circumstances. We don't have that from Westgate here. Cocorello, there was a physician who was actually there and treating the individual who was choking. As Judge Lambert noted, when that individual is present, the duty to render aid does not exist. There was no one here at this time that could have provided the first aid that the physician in Cocorello was in the position that Mr. Rizzo was in. And so we are dealing with completely different factual circumstances from that in Cocorello, such that we could say there was no breach as a matter of law. Again, would request that this court reverse because the question of breach is a fact question. That's truly what we're talking about, and we would request this court reverse the final judgment.
All right, thank you both for a well-argued case. Court will be recessed.